I just need to text Parrish because he was wondering what was going on. So I'll send him a message and make sure he's sorted out. So welcome to the leadership session here at the 2021 EOCP conference. And to kick things off, I have Heidi Rolfe here, and she's going to be presenting Under Pressure, Responding to Regulatory Inspections and Investigations. So Heidi is an associate in the Environmental, Municipal, Exploration, and Regulatory Group in BLG's Vancouver office. She has a wide range of legal experience, guiding individuals, companies, and government agencies through regulatory processes, administrative and civil proceedings, and quasi-criminal environmental prosecutions relating to natural resource construction and other industrial projects. She has also assisted developers and property owners dealing with redeveloping and remediating contaminated properties, including disputes between neighboring property owners and navigating environmental cleanup orders. Prior to joining VGL, Heidi clerked at the Federal Court of Canada and practiced in the Vancouver office of an international law firm. So please welcome Heidi.
Okay, thank you for that kind introduction. And again, sorry for the technical difficulties this morning, everyone. So I'm going to try to go through and get started as quickly as possible. So today we're just going to start off with an overview of environmental jurisdiction in Canada. So as some of you may be aware already, this is an area where both the federal and provincial governments have jurisdiction. So it's overlapping and concurrent. And this often means that you'll have multiple governmental agencies that have an interest in any given environmental matter. Government agencies or regulators are the ones that have the authority to oversee, implement, and enforce regulatory regimes. So here are a few examples of provincial jurisdiction. These are government regulators and some of the legislation, and you'll see in red those are some different pieces of legislation that apply specifically to water and wastewater. And then again, we have different federal regulators, and there again, in red, we have some of the legislation that gives them the authority over things that relate to water and wastewater treatment. So compliance versus enforcement, it's really important to understand the difference between compliance and enforcement actions and the different ways that the government might interact with a particular company or business based on which sort of hat they're wearing at the particular time. Compliance relates to whether or not a business complies with regulations, standards, licenses, permit conditions, things like that. Examples of that are inspections, monitoring, data review, reporting requirements, while enforcement is about compelling offenders to comply with the law, and examples of that are investigations, warnings, and various types of penalties, including potential prosecution and court orders. So these are the main sort of two buckets of tools that government agencies use in order to carry out objectives of environmental legislation. And they often have a lot of broad jurisdiction to decide which tools to use in a given circumstance. So for today's presentation, we're going to be focused on inspections and investigations. In terms of recent trends, we're seeing a lot more focus both at the federal and provincial level on environmental protection, and this has led to more compliance inspections and investigations, more frequent and more serious environmental prosecutions, and dramatic increases in monetary penalties and fines arising from noncompliance. An example of this is a recent case involving Teck Coal. So sometime in about 1995, it was discovered that surface coal mining was appearing to mobilize soluble selenium into the Fording River. At some point before 2009, Teck Coal became aware that selenium and calcite associated with their mining operations could be environmentally harmful. In 2012, Environment and Climate Change Canada, that's a federal agency, conducted sampling and testing and found that there were selenium concentrations in a particular species of fish that were associated with adverse effects. Between 2012 and 2019, so that's a 7-year time span, there was a comprehensive investigation by Environment Canada, and during that time, the company also took steps to address the releases. In October 2020, so again, 8 years following that initial, what you might call an inspection, that sampling and testing, 2 charges were laid under the Fisheries Act, and Teck pled guilty to the charges and was ordered to pay a total of $60 million in fines and monetary orders. And that's the largest monetary penalty in an environmental case to date. So as you can see, the penal consequences can be quite serious. So moving on to part 2 of the presentation, so focusing on those inspections and investigations. A little video, but given the time, I think I'm going to skip that, but you can view it later because there'll be a copy of this available. So what is an inspection? As I mentioned before, the main purpose of this sort of routine administrative tool is to get information and determine whether or not a business, a facility is in compliance with environmental laws and standards. And if there is an ongoing environmental event, such as a spill, abatement would also be involved in that inspection. Typical activities, they'll tour the facility, make observations, they may take photographs or video recordings, taking tests, samples. They might ask to examine and take copies of documents, and they might also ask to speak to staff and other employees. So usually this type of tool is used to get information on compliance status, and this is specifically for facilities that are already operating within a regulatory system. So it's premised on the notion that you're carrying out a regulated activity, and the fact that an inspection can occur is a condition of engaging in that activity. So in contrast to that, we have investigations where the main purpose is to obtain evidence relevant to the prosecution of possible statutory violations. The activities often look similar. However, inspectors cannot use, or investigators at that point rather, cannot use inspection powers. So they can't compel statements from employees or agents. They cannot demand documents, and they cannot conscript evidence. And we're going to get into the reasons for that on the next slide. So I know this is a lot of text, but I'm going to hope to make it a little bit more interesting. And if there's anyone interested in law and order, some of this might sound a little bit, familiar to you, because we're stepping into sort of the quasi-criminal portion of things. So in terms of the basis for an inspection, that is just based on their statutory authority. Whereas with an investigation, there have to be reasonable and probable grounds that an offense has been committed for an investigation to take place. Do they need a warrant? For an inspection, no. Regulators generally have rights to go in and conduct the types of activities that I mentioned earlier when doing an inspection, as long as they're there at a reasonable time. What are the facility's business hours? And they can generally do things, as they please, making copies of documents as long as they return them promptly and as long as it's a reasonable request. Whereas with an investigation, a warrant is usually required. This is under the Protection Against Unreasonable Search and Seizure, which is a charter right. And it's on its face, it's usually deemed to be unreasonable to search or seize without a search warrant. And so they must either have, a judicially ordered search warrant, so they go before a judge, or consent by the facility to enter the premises or seize documents. There are some exceptions to this, such as exigent circumstances. So an example of that would be an immediate hazard or risk, or if they believe that evidence may disappear if it's not immediately secured by the regulator. So that's basically a judgment call that's made by the authorities at the time, and the legality of that is determined after the fact. A right to silence in an inspection, no. Generally, employees and agents must answer the inspector's questions if the information is for the purpose of ensuring regulatory compliance. Whereas under an investigation, yes, there is a right to silence, which is Charter Right Section 7, and however, this only applies to individuals, not corporations. And so that could be somebody like an employee, director, officer, et cetera. They can't be asked to speak to investigators for the purpose of determining any kind of penal liability. You have an individual right not to answer, so a right to silence, but not a right not to be questioned. So you can still be asked questions, but again, you could assert that charter right as an individual. And then right to counsel. In inspections, it's not always clear. Often, we would recommend having legal counsel involved, whether that's in-house, someone from your in-house legal team, or external counsel. Be present just to make sure that an inspector is asking reasonable questions, but it's not, again, clear if you can actually refrain from answering any questions before counsel arrives. Whereas in investigation, yes, you do have a right to speak to counsel without delay under the charter, which basically means they have to give you an opportunity to speak to counsel before answering any of the questions. And you can actually insist that you're not going to answer any questions before speaking to a lawyer as well. So how to tell the difference? It's often difficult to distinguish between an investigation and an inspection in the moment. And an environmental incident can actually result in an agency performing both functions, and an inspection can actually turn into an investigation during the course of a visit. So say that they uncover something and then suddenly they're thinking, actually it looks like there has been a violation here and we're going into investigation mode. This is also complicated by the fact that any particular environmental incident can also attract attention from multiple different agencies acting under federal, provincial, and even municipal enactments. And within each level of government, multiple agencies might be involved. So for instance, a marine spill, so something has spilled from an oil tanker or a ship, Transport Canada, Coast Guard, Environment Canada, and Departments of Fisheries and Oceans would all have an interest in that particular event. And so you would have multiple agencies sort of coming to your door. And given those consequences that I mentioned earlier, it's really important to understand the difference and to be able to spot the transition to an investigation. So you have to consider what is the predominant purpose of the inquiry. And the case law uses the term crossing the Rubicon. So that's Julius Caesar there in the photo, crossing the Rubicon River, when the main goal is the inquiry to conscript evidence for enforcement and determine penal liability. And these are some of the factors that you can look at to determine if things are moving towards an investigation. Again, this is from the case law. Each of the factors here are fact-dependent. Each case is going to have a lot of unique considerations, and these factors can help flesh out which is occurring, but ultimately the court is going to look at the totality of the circumstances. And again, this is a really gray area, and it's hard to determine in any given case. We have a couple examples here. The first is a case from 2020 involving Fraser River Pile and Dredge. So Environment Canada, again, that's ECCC, that's the regulator, learned of possible unlawful dredging activities in Northwest BC by Fraser Pile and Dredge, and that was conducted on behalf of Stewart Bulk Terminals. The investigators went to the bulk terminals premises to obtain information from the owners and operators. They said that they were enforcement officers. They said that they were investigating the recent dredging. They conducted interviews. However, they did not, among other things, advise the owners of their right to refuse to provide information. Again, remember, this was an investigation. And owners were told that they were being interviewed as, quote, witnesses. And the owners later said that they believed that they were legally required to provide assistance to the investigators. So again, sort of saying, we thought this was an inspection. Oh. There we go. So we don't need to get into sort of the procedural details, but there was a preliminary hearing to determine whether or not a process called a voir dire which is another type of hearing to determine whether or not that evidence from those interviews was going to be allowed into the trial. So again, these were the different arguments that were made. So under Section 7, the right to silence, the court said that there was valid informed consent requires an understanding and appreciation of the rights being waived. So saying, yes, I'm going to speak to you anyway, and the consequences flowing from that waiver. So in this case, there was a question to be answered at that secondary process regarding the validity of the consent, because it wasn't clear if they actually understood what they were doing. Section 8, unreasonable search and seizure, they had met the low threshold for moving to a voir dire and right to a fair trial. This is kind of an interesting argument from a legal perspective. The applicants argued that the investigation had been conducted in such a manner that was egregious, that it would so egregious that it would offend society's sense of fair play and decency, and essentially was an abusive process, and it would undermine their ability to get a fair trial. So usually that type of argument is reserved for individuals and not corporations. So we'll have to wait for the actual trial to see how that's resolved. But again, it's sort of an example of how your legal counsel can push back in sort of the first stage. So when you're actually going through the investigation, but if it comes to it before the courts as well. And in another case, again from 2020, this case involved Banks Island Gold, and it arose from alleged offenses at a gold mining site. The offenses involved were failing to report a spill under BC legislation and failure to report the deposit of a deleterious substance under the Federal Fisheries Act. So again, we had multiple regulators involved. The individual defendants, so employees, gave two different statements on two dates. The Crown wanted to rely on the observations made by their officers during the visits, both statements, and a later report on the spill. And the defendants argued that the evidence should be excluded due to breaches of charter rights. So at first instance, the trial judge admitted the observational evidence, portions of the first joint statement, and the report, and this was appealed. So, and at that appeal, the court held that defendants were subject to inspection within the regulatory context. They always carries the risk of penal liability for noncompliance. So in terms of deciding what evidence should go in, that context was important, and the relevant question was whether the officers' regulatory inspection powers were exercised reasonably in the totality of the circumstances. The observational evidence, not surprisingly, so just what the officers saw when they attended at the site, that was allowed in. However, the statements were a little bit more complicated. So first they had given a joint statement. So it started as an investigative interview. It wasn't a regulatory matter, so not an inspection. The interview did shift to regulatory matters without being advised that, certain questions related to the investigations had concluded. And while there could be a regulatory inspection and a criminal investigation inquiry at the same time, once the inquiry involves the investigation, again, we have to comply with the charter. They had been interviewed by 4 investigating officers. They knew that they were obligated to provide certain information under the regulatory framework, but also that they were being investigated for potential offenses. However, again, the court said there's no clear delineation during that interview about the different portions, and they weren't satisfied that the charter rights had been protected, so that entire statement was excluded. This is in contrast to the later statement. Again, these were individual statements, not joint, and those interviews focused on the lack of compliance and the later alleged events relevant to the offenses. So there's 2 fisheries officers conducting the interviews. The court said this was clearly an investigation. There was no sort of other inspection that preceded it, no search of the mining site, no discussions, clear warnings were given, and it was unlikely that the defendants at that point were confused about what exactly was happening and their right to silence. So the judge allowed that evidence in. And finally, the spill report was also admissible. So ultimately, they're going to get a new trial in this matter, and the Court of Appeal denied leave on these issues. So now we're going to finish up with some sort of tips and best practices. So how do you actually put this all into action? Because I know I've been sort of speaking a lot of legalese, and we all want to know, how does this actually work in practice? So before an inspection or an investigation, it's important to designate a representative, someone who's going to act as the point person, who's authorized to speak on behalf of the company should an inspector and investigator come. That person should be knowledgeable about the environmental laws, procedures. They, need to have good interpersonal skills, be skilled at negotiating, have a relationship with legal counsel, and be sort of trained and equipped to take samples should that be required. They should also be familiar with, all aspects of the operation. Something that could be asked, for instance, could be, where do all the drains discharge? So you need to know that, even if it's off-site. What approvals, permits, and licenses that your facility has. What any consultants, contractors, third-party suppliers, et cetera, are doing on your behalf, and the legislative, inspection and investigation powers that apply. Then it's also really important to keep your environmental records organized and readily accessible for that representative and any other people that might be involved. So that includes, the items listed here, approvals, permits, licenses, records of inspections, even if those are internal, monitoring, sampling, testing results. If there's required training under your legislation, then that's important to have those records accessible as well. Something else that can help is having an internal procedure for engaging with government officials and regulators. So again, this is about making sure that your designated representatives, your point people, know how to engage, and that there's some sort of consistent way that they're going to do that. However, it's important that all personnel do have some level of familiarity with inspections and investigations, just so that they know how to recognize when it's important to involve that representative. So at the outset of an inspection or investigation, so the regulatory official has come first. And this is probably the most important step for most personnel, is to direct those officials to and notify that pre-appointed representative. They should be told that only the company representative is authorized to speak on behalf of the company, and that all requests are to be directed to that person. So again, they should be trained to execute that step. So even if it's, your receptionists, anybody who might come in contact with the government official, they have to be aware of who that company representative is and how to get in touch with them. That representative, their first order of business is to determine the purpose of the visit. So is this an inspection or is this an investigation? Again, you can just ask that, and then you'll also be wanting to get some of those context clues that we discussed earlier. So again, this will dictate how the company representative should act and what next steps they might need to take. So you should also be asking the officials, what is the purpose of the visit? Asking them to provide credentials, specify what legal authority they have, and most importantly, is identifying the scope of what is being inspected or investigated. Is this the company as a whole, an employee, a third party, such as a supplier or contractor? And how are they going to conduct that inspection or investigation? What location on the premises? Are they going to be taking samples? Do they need to examine or copy documents? And are there going to be employee statements or questioning involved? During an inspection, so again, here we're in our sort of regulatory sphere. The company representative should still accompany those officials at all times, try to, again, determine the scope and what they're going to be doing. Generally, you're going to be required to provide all compliance-related information that's requested and document as much of the regulatory visit as possible. So take timely notes, whether that's as you're viewing the facility with them or right after, requesting copies of photographs, recordings, anything taken by the government officials, making copies of anything that they are going to be taking off site in terms of documents and records. And at this stage, if an officer clearly states that it's an inspection, legal counsel doesn't necessarily need to be involved. But again, it might be helpful just to ensure that the inspection remains reasonable. And a good way to sort of judge this is often that scope question. So if the official says they're only going to observe, so they're only going to sort of walk around, they're not going to take any samples, they're not going to ask any questions, usually legal counsel will not be required at that point. But if they intend to do something like examine documents or question individuals, it is important to notify legal counsel and ask to wait until counsel arrives, or can at least get in touch with the official. So even if it's a phone call and you ask the government official to speak to your legal counsel over the phone, that's a good option. Again, if no counsel is available, they can't come to the site, they can't take a phone call, you could ask if the government official can undertake that there's going to be no penal consequences. So no sort of quasi-criminal liability that will result from any interviews or document examination. And if they say no, if they won't make that undertaking to you, again, in sort of best practice would be to treat it as an investigation at that point. And again, you have to be very careful about that possible transition during the same visit or subsequent visits from an inspection to an investigation. So just because they say when they show up, this is just a regular inspection, nothing to worry about, we're just here to observe, just be aware that it can turn into an investigation quickly. And if you suspect that this may have occurred, again, you can confirm. And yeah, if they say yes, it's important to ask that they take no further steps, call your legal counsel, and again, you can also have them speak to legal counsel over the phone. During an investigation, so again, because this is the one that has penal consequences and sort of quite serious consequences, it's important to consider contacting legal counsel and acting on their legal advice as soon as possible. The first step is often to determine if government officials have a search warrant. If they do, you would be recommended to get a copy of that search warrant if possible, and determine if there are any limitations on what's actually authorized under that. So you're going to want to look at those terms really carefully. For instance, authority to search computers, phones, tablets, things that we often use in today's workplace, that would need to be specifically set out in any search warrant. However, they may still decide to seize that type of equipment to ensure evidence integrity. Again, remember there are exceptions to this. It could be searched incidental to arrest or under authority for a warrantless search. If there is no warrant, then you would be asking them to confirm their authority to conduct a warrantless search, such as those legislative exceptions. And if there is no authority for a warrantless search, those officials can only lawfully search and seize property with consent from the company representative. And at that point, if there's no warrant and there's no authority that they're citing, it's in the regulated entity's hands to decide whether and to what extent they're going to cooperate, on what terms they might cooperate. There are some, there's always good and bad to anything. So if you do decide to cooperate, it's possible that an investigator might find some harmful evidence that may have gone undiscovered otherwise. And all evidence that's provided voluntarily will likely be admissible in a subsequent prosecution. If it was decided not to cooperate without a warrant, sometimes this might be just delaying the inevitable. They might be able to obtain a search warrant anyway. You do sort of risk some type of backlash by sort of forcing an official to, jump through the hoops. And a lawful, even though you do have the right to refuse without a warrant, that lawful refusal to cooperate might be painted in such a way to harm the company at the sentencing stage of a subsequent prosecution. So, it really cuts both ways. So again, that's probably why we would suggest having legal counsel involved in that conversation. So again, during the investigation, we would say try to get as much as possible information as possible about the nature of the investigation. Again, observe, document, report on that investigation for your legal counsel, taking notes, getting copies of everything, taking the same photos is often very helpful, making sure that you take identical samples. Don't answer any questions of a substantive nature unless, of course, your counsel has given you the green light to do so. Mark all notes as being privileged and confidential for legal advice, and the same goes for any related documents. And that, again, just makes sure that those documents are protected under the blanket of legal privilege. Employee statements. This is sort of our last main topic. So again, during an investigation, they may ask you to speak to employees or agents. So you'll want to get a list of who they want to interview, and if at all possible, arrange those interviews in the future, just so that those employees can have some time to prepare. Before they give a statement, it's important to confirm the scope of that interview. Are they being investigated personally? Is it being conducted as part of, the company's investigation? The decision to make a statement ultimately belongs to the individual themselves. There's no legal obligation on their behalf to provide a statement during an investigation, and they have a right to seek independent legal advice. So that would be from a lawyer who works for them and not for the company, and it's usually best practice for the company to let the employee know that they have that option. And it is also an offense to tell an employee not to give a statement to a regulator or to potentially try and shape their statement in any way. So if they are ultimately interviewed, again, the company representative and the company's lawyer should be present if at all possible, and you'll want to get copies of if they give a written statement or if there's a transcript or recording of them. And then finally, after an inspection or investigation, you'll want to prepare an internal report, get copies of everything that we've talked about from the government officials, provide that report and documentation to the appropriate persons in the company, so directors and officers, legal counsel, and sort of any internal teams or consultants that might need that information. You'll want to prepare for future regulatory visits, so reflect on, what went well, did we have any issues, and make sure that your protocol is updated. And just remember that, just because you don't hear anything right away, that doesn't necessarily mean anything really. Government officials will usually prepare a brief to Crown Counsel, who then decide if charges are going to be pursued. And in many cases, it's a long limitation period. So it could be up to 5 years or more to apply for filing charges after an alleged offense has been committed. So I'd hope to have a little bit of time for questions, but I think we have a couple minutes maybe, or a couple questions.
Heidi, I want to say thank you for that presentation, first off. That's great. I think as water and wastewater operators, we're fairly used to regulators coming in, but understanding what an inspection is versus an investigation. I think that's really good information, so thank you. We do have a couple of questions here. One's from Keltna, and it says, do federal regulations supersede provincial regulations?
So no, they do not. Again, this is just sort of an issue about having parallel or overlapping areas of authority. So, there are certain circumstances where they're going to be complementary, and there are other circumstances where something is clearly within the federal government's sort of wheelhouse within their jurisdiction. So, for instance, a spill or a release of some kind of substance into a stream could have provincial regulators sort of under the Environmental Management Act, as well as the Canadian Environmental Protection Act. So it'd be Environment Canada, as well as the BC ministry involved. But then also you might have DFO on sort of a fisheries issue as well. So.
Thank you. We just have one more question here.
Sure.
With the recent adoption of regulatory requirements for higher risk water systems in Vancouver, public health investigations into Legionella outbreaks are performed by an agency that is not responsible for compliance with the regulation. So that being said, how would the information collected during that investigation be treated under the inspect versus investigation framework?
Well, I'm not really familiar with that particular set of circumstances, so I can't really say for sure. So I hate to do this, but I'm going to put up my contact information on the next slide. So if you have more questions even beyond this, I'm happy to chat over email. You know, generally speaking, I would suggest that a third-party agency or a third-party company who's doing something is most likely to be in sort of the inspection realm. Again, just because the authority to actually conduct an investigation that's more of a criminal nature, I doubt would be sort of delegated beyond government agencies.
All right, thank you very much, Heidi, and thank you for that presentation today.
Okay, thank you.